Friends, today we will discuss one of the very important aspects of international humanitarian law. The name of the topic is protection of prisoners and civilians under custody. Since time immemorial, there have been war and war. And in spite of its outlawing by the United Nations Charter, war are taking place even now. And they will continue to take place in future also. If there are war, a natural corollary is that there must be always prisoner of war. The rules protecting prisoner of war are specified and were first detailed in the 1929 Geneva Conventions. They were redefined in the third 1949 Geneva Conventions following the lessons of World War II, as well as in Additional Protocol 1 of 1977. In next, let us see who are the prisoner of war. Prisoner of war are members of armed forces of one of the parties to the conflict who fall into the hands of adverse party during an international armed conflict. A number of other categories of persons are also listed in the third conventions, that is convention relating to the treatment of prisoner of war 1949, having the same status as the member of armed forces. They are: number one, member of a resistance movement belonging to a party to the conflict who satisfy the following four requirements. The requirements are: they must be commanded by a person responsible for his subordinates. They must have a fixed distinctive sign which is recognizable at a distance. If they have no uniform of their own, they must carry arms openly, and they must respect the law and the customs of war. Number two, certain persons authorized to accompany the armed forces without belonging them. For example, civilian members of a ship and aircraft crew, war correspondents, though not those journalists who are not to be treated as civilian under the rules of Additional Protocol 1. Number third, levy in mass. They are members of the populations who are spontaneously taken up arms to resist approaching enemy forces. Members of medical services who are taken prisoner of war are granted special status. That is, they must be given the care of prisoner of war of their own side, or be returned to the party to which they belong. In general, any doubt as to the status of a captured persons must be cleared up by a competent tribunals. Prisoner of wars keep their legal status from the time they are captured until they are repatriated. During the captivity, prisoner of war retain their legal status as a member of armed forces, as indicated externally by the fact that they are allowed to wear their uniform, that they continue to be subordinate to their own officers, who are themselves prisoner of wars. Next, we will discuss on treatment of prisoner of wars. So we start from certain case studies, that is how prisoners of war are treated during Second World War. So let us see how the prisoner of war are treated in the World War II. During operations Barbarossa, the Axis invasions of Soviet Union and the subsequent German-Soviet War, millions of Red Army prisoner of wars were taken. Some of them were arbitrarily executed in the field by the German forces, died under inhuman conditions in German prisoner of war camps, and during ruthless death march from the front line, or were shipped to Nazi concentration camp for exterminations. Not only this, friends, some 3.3 million Soviet prisoner of wars died in Nazi custody out of 5.7 million. This figure represents a total of 57% of all Soviet prisoner of war and may be contrasted with only 8,300 out of 231,000 British and United States prisoners, or 3.6%. The most deaths took place between June 1941 and January 1942, when Germans killed an estimated 2.8 million Soviet prisoner of war, primarily through starvations, exposures and summary executions. On the other hand, between 374,000 and 1 million German prisoner of war out of estimated 2.4 to 3.3 million also died in Soviet labor camps. Those who have prisoner of war status enjoy prisoner of war treatments. The detaining power is responsible for treatment of prisoner of war. Friends, the third conventions, that simply you can say prisoner of war conventions, in Article 12 to 108 regulate to the smallest details of the treatment of prisoner of war. Combatants who fall into the enemy hands are prisoner of war from the moment of captures. Prisoner of war may only be transferred by detaining power to a power which is a party to the convention. Third, prisoner of war must at all times be humanely treated. It is prohibited to cause death or serious endangering the health of prisoner of war in custody, or measures of reprisals, or subjecting them to the physical mutilations or to medical or scientific experimentation of any kind, or torture or severe ill treatments. Friends, here we'll discuss on one particular case studies that also relating with Second World War. During Second World War, between 140,000 and 500,000 Soviet prisoner of war died or were executed in Nazi concentration camps, most of them by shooting and gassing. Some were also experimented on. In one such case, a Dr. Heinrich Böning from Hamburg University starved prisoners to death while performing famine experiment. In another, prisoners were shot using dum-dum bullets. These are the provisions, or these are the case study how German violated prisoner of war conventions. When captures, prisoners of war are obliged to give name, military rank, date of birth and a serial number only. They cannot be compelled in any circumstances to provide further information. Prisoner of war captured in a combat zone must be evacuated as soon as possible out of the danger zone and brought to a place of safety. Every prisoner of war camp shall be put under the immediate authority of a responsible commissioned officers belonging to the regular armed forces of the detaining power. This officer who, under the direction of his government, bear responsibility for the application of this convention in the prisoner camp. In this aspect, friends, again we need to study one particular case study that also relating with Second World War. In the Second World War, the prisoners were stripped of their supplies and the clothing by ill-equipped German troops when the cold weather set in. This resulted in fatal consequences for the prisoners. The camp established especially for the Soviets were called Russian lagers. In others, the Soviets were kept separated from the prisoners of other countries. The Allied regulars kept by Germans were usually treated in accordance with 1929 Geneva Convention, Old Geneva Convention. Here, this 1929 Geneva Convention was signed by Germany but not by the Soviet Union. However, it should be noted that since Germany signed the convention, it was required to treat all captured soldiers in accordance to it, whether they were from signatory state or not. In the case of Soviet prisoner wars, most of the camps were simply open areas fenced off with barbed wires and a watchtower with no housing. This meager condition forced the crowded prisoners to live in holes they had dug for themselves, which were exposed to the elements. Beating and other abuse by the guard were common, and the prisoners were malnourished, often consuming only a few hundred calories per day. Medical treatment was non-existent, and an International Red Cross offered to help in 1941. That offer was rejected by Adolf Hitler. Friends, these are how prisoners were treated during the Nazi regime and the Second World War. Prisoner wards in good health may be required to work, but may be employed in a dangerous work only if they volunteer. Removal of mines is explicitly mentioned as dangerous work. In this aspect, we need to study another case study, that is a forced labor camp during Second World War. In January 1942, German leaders decided to use prisoners for forced labor. They used about 631,000 prisoners of war, and many were dispatched to coal mines, whilst others were sent to Krupp, Delmers, Benz, or countless other companies, where they provided labor while being slowly worked to death. More than 200,000 prisoners died during forced labor. So see, friend, how prisoners are used as a forced labor that is prohibited by the Geneva Convention in the Second World War. In the case of an attempt at escape, which remained abortive, exposes the prisoner of war to nothing more than disciplinary punishment. Prisoner of war may be interned. The purpose of this internment is not to punish them, but only to hinder their direct participation in hostilities and or to protect them. Prisoner of war is subject to the law in the country of the detaining power, especially the regulations applying to the armed forces of that country. Friends, next we'll see transmission of information and monitoring by outside mechanisms under this topic. Rules concerning transmission of information and correspondence regarding prisoner of war is also regulated by Third Geneva Conventions. Prisoner of war are entitled immediately upon capture to complete what is called a capture card, which is then sent via the International Committee on the Red Cross Central Tracing Agency to the official information bureau in the prisoner's own country. The letter has a task to inform the prisoner's relative. They are entitled to correspond with their relatives. They may also receive aid in the form of individual parcels and collective shipments of all sorts, such as well-known Red Cross parcels. Representatives and delegates of protecting powers and International Committee on the Red Cross are permitted to go to the all places where prisoners of wars are kept, interned, imprisoned, and labored, and they also have right to interview the prisoners and the prisoners' representative without witnesses. During Afghanistan conflict, thousands of families in Afghanistan are separated from their relatives who are detained by Afghan authorities and international military forces. Restoring contact between these families is often challenging because most do not have the economic means to travel in order to visit their father, brother, or sons who are detained in different parts of the Afghanistan. The International Committee on Red Cross, in collaboration with Afghan authorities, make it possible for this family to maintain contact with their loved one detained and at the Parwan detention facilities in Bagram by organizing face-to-face visits and facilitating telephone calls from its offices around the country. So friends, we have seen how ICRC worked in the family link in the prisoner of war camp. So in the next, friends, let us see repatriations and release on the parole of prisoner of war. As prisoner of wars are only detained to stop them from taking part in hostilities, they have to be released and repatriated when they are unable to participate, that is, during the conflict for health reasons, and of course as soon as active hostilities have ended. It should be recalled that as a rule, prisoner of war cannot refuse repatriations. Under the influence of human rights and refugee laws, it is today admitted that those fearing persecutions may not be forcibly repatriated. For instance, after the Korean War, when numerous North Korean prisoners in American hands refused to be repatriated. In such circumstances, each individual case must be handled in a way that is humanly acceptable, and ICRC may take proactive role in this regard, in particular to determine objectively each prisoner's will. Friends, prisoner of war must be released and repatriated without delay after cessation of active hostilities, but the severely wounded and sick prisoner of war must be repatriated directly and without delay as soon as they are fit to travel. Without waiting for the war to end, the party to the conflict also can repatriate prisoner of war on humanitarian grounds, possibly on a reciprocal basis, by means of an exchange of prisoners. The International Committee on the Red Cross, as a neutral intermediary, always tries constantly to bring about agreement of this kind. In the event of less serious situation, but where the release of prisoner of war may contribute to the improvement of their state of health, detaining power may offer to release them partially or wholly on parole or promise, insofar as is allowed by the law of the power on which they depend. Friends, here we will see one case study in this, how prisoner of war are repatriated after the war or during the war. On 16th and 17th June 2002, following agreement between the authorities of Democratic Republic of Congo, Rwanda, Zimbabwe, and Namibia, the ICRC repatriated 177 former prisoners of war of Rwandan, Zimbabwean, and Namibian nationality who had been detained by the various belligerents in the Congo. More than 90,000 Pakistani prisoner of war who were captured by Indian armed forces during the Indian-Pakistan War of 1971 were also released by India after negotiations and the signing of Simla Agreement on 2nd July 1972. Following the Paris Peace Accord of 1973, 591 American prisoners of war were returned during Operation Homecoming during Vietnam War. Friends, what we discussed in the preceding part are how prisoners of war treated under international humanitarian law. Next, let us see how civilians under custody are treated under international humanitarian law. Civilians may be kept under custody during armed conflicts. They are protected persons under international humanitarian law. For imperative security reasons, protected civilian may be interned. Such internment is not punishment. This applies both to persons in the hands of adversary on his territory and to the inhabitant of an occupied territory. Geneva Convention 4 or Fourth Geneva Convention provides comprehensive provisions dealing with internment of civilians. These provisions cover the legal status of internees in every details and prescribe their treatments on the line of that specified for prisoner of war. It is also mentioned that all information concerning internees must be sent via National Information Bureau to the ICRC's Central Tracing Agency for forwarding to the internees' own country. In non-international armed conflict, Article 3 common to the 1949 Geneva Conventions and Additional Protocol 2 provide that persons deprived of liberty for reasons related to conflict must also be treated humanely in all circumstances. In particular, they are protected against murder, tortures, as well as cruel, humiliating or degrading treatments. Treatments of persons arrested, detained or interned who are not protected by the 4th Geneva Conventions for acts related to armed conflict are dealt in Article 75 of the Protocol 1. Civilian persons in international armed conflict entitled to the protection of Article 75 are to be treated humanely in all circumstances without any adverse distinctions. Any person arrested, detained or interned for actions related to armed conflict has a right to be informed promptly in a language he understands of the reasons for such a measure depriving him of his liberty. Except for penal offences, such a person should be released with a minimum delay, and as soon as circumstances justifying the arrest or internment have ceased to exist. No sentence may be passed and no penalty may be executed on a person found guilty of penal offence related to the armed conflict except pursuant to convictions pronounced by an impartial and regularly constituted court, respecting the generally recognized principles of regular judicial procedures. Friends, women or children whose liberty has been restricted for reasons related to armed conflict must be held in quarters separated from men's quarters or from the quarters of adults, except where families are accommodated as family units. Women must be under the immediate supervision of women. Pregnant women and the mothers having dependent infant must be considered with utmost priority. Now we will come to the concluding part of this topic. In conclusion, we may say war is an inevitable, and if there are war, a natural corollary is that there must be always prisoner of war. The 3rd Geneva Conventions and the Additional Protocol 1 provides a wide range of protection for prisoner of war. It defines their rights and set down detailed rules for their treatments and eventually release. International humanitarian law also protects other persons deprived of their liberty as a result of armed conflict. Rules governing the treatments and the condition of detentions of civilian internees under international humanitarian law are very similar to those applicable to prisoner of war. Apart from this, a body of unwritten customary international humanitarian law which supplements the codified international humanitarian law provisions. So, we may conclude that protection of legal regime for prisoner of war and civilian under custody is very comprehensive and complete under international humanitarian law.